The relationship in this, the property that is in dispute pertains to is divided into 4 schedules, and that is important because Schedule A is 2 kattha land in plot number 51 under Khata 11. Schedule B is another 2 kattha. Lot number 51 under Khata 11. This was purchased on 19th December 1949 by registered sale deed. Again, we are relationship in Schedule B, 2 katthas land, lot number 51 under Khata 11, and this was purchased by registered sale deed on 20th of January 1954. Thereafter, there is Schedule C land, which talks about 9 decimal area in plot 50 and plot 51, Khata number 11, which is admittedly an encroached land, which we have encroached upon, the plaintiff. And Schedule D is A plus B plus C, total 16 decimal of land.
A plus B plus C.
Yes, sir. Total 16 decimal of land.
2 kattha constitute how many? How much decimal?
4 decimal is what my client informed me.
9 decimal. Then 2 kattha and 2 kattha constitute how many decimal?
Apologies, Your Lordship. I'll tell you exactly how much my client. 3.5, and apparently according to the total, because this is what the measurement is given in the title suit also and every document.
It doesn't match, no? 16, how it's 16 decimal?
That is what the schedule is also there.
So if schedule is also 16, it's okay. You don't want to say anything. But D includes A plus B plus C, and that you have made it up to 16. But it is not matching. Not at all.
2 kattha, and then they became 16 decimal is Schedule D.
2 plus 9 decimal. 2 kattha, 9
and 9 decimal.
1 kattha is how much decimal?
Decimal. Asked for
1 kattha.
2 kattha.
No.
2 kattha is 6.25 decimal.
No.
1 kattha is 3 decimal, 3.12. If the dispute is not.
Anyways, this is what. So what do you want to say?
Yes.
Concurrent finding?
Yes, sir. Plaintiff, appellate, and here also we have appellate. Your Worship,
What is the substantial question?
Your Worship, the substantial question of law is at page 8 of my second appeal. You'll be pressing the second substantial question of law, where in absence of any documentary evidence to rebut the possession and title via Exhibit 6 and 6A, court can pass an order in favor of the defendant. Your Worship, in our case, we have purchased the land through registered sale deed. Our prayer was for declaration of title with respect to only Schedule B land, and thereafter we have asked for permanent injunction with respect to Schedule D land.
But 3.125 decimal. तो 15 में नहीं जाता है.
An injunction with respect to Schedule D.
Schedule D land. Right of interest, Schedule B, and permanent injunction for Schedule D land.
You are in possession of Schedule B.
Yes, Your Worship. In fact, they have stated in their written statement that my predecessor, my grandfather is at best a trespasser, and moreover, your ladyship, my possession is also being recognized by the trial court judgment itself. I can show you the page number, your ladyship. At page 10 of the trial court judgment, at page 34, the evidence of PW1, PW2, PW5 along with municipal documents do show the possession of the plaintiff over the part of plot number 51, but there is no evidence as to whether this possession was hostile to the real owner. So my possession is also shown. The title should, they have accepted my possession, the learned judge. The respondents are saying that they have acquired the land in 1952-1953, but they have not brought on record any document to that effect. They have only brought on record a map that shows that 89 acres something has been acquired. That too, the plot number is not mentioned, your ladyship, and that too has come in the trial court finding, your ladyship. At page number 11, it may be seen, your ladyship. But from perusal of these maps and plans, it is not clear as to what plots have been acquired by the
Land of how many?
Pardon me, your ladyship.
What is the area of the acquired?
89.90 acre of Barmasia Moja was acquired by railway. But from perusal of these plans and map, it is not clear as to what plots have been acquired by the railway. And no other document has been produced by the defendant to show that the plot number 51 or 50 of Khata number 11 was acquired by the railway. This is a categorical finding. Also, they have not produced any land acquisition document before the lower court. They have claimed title on the basis of the title deed, your ladyship, which is 1949 and 54, which is very old, your ladyship. It is more than 30 years old. So section 90 comes into play, your ladyship. Plus, your ladyship, a pleader commissioner was appointed. That was with the consent of the respondents before filing of the written statement. That they had submitted the report, and the pleader commissioner has clearly given the boundary, clearly recognized the pieces of land, submitted his report saying that my possession is there for several years now, and despite that, it was not taken into account only because he had not marked it as an exhibit. There was no protest from the respondent side regarding the report.
Did you claim adverse possession?
Your ladyship, there was no averment in the plaint stating adverse possession, but we have stated that we are in possession of this
That is
land.
not sufficient. Long possession does not
respect to
long possession ipso facto does not convert itself into adverse possession.
Yes, your ladyship. But in this matter, your ladyship, my title deed is of 1954 and 1949, and my possession is also recognized. And the judgment talks about Schedule D में मेरा title नहीं, whereas I am only claiming title for Schedule B land, your ladyship. They have also not brought a single sheet of paper to show that they have ownership over the land. And whenever the ownership is disputed or whenever there is an issue with ownership, Section 114 of the Evidence Act will also come into play, your ladyship.
There are two sale deeds, Exhibit 6 and 6/8.
Yes, your ladyship. Schedule A land, Schedule B land. And Schedule B land is plot number 51. And for plot number 51, the trial court has given a finding categorically saying that I have possession in Schedule B land.
For Schedule C, you are an encroacher.
Yes, admittedly, I have said that my grandfather found this land being close to Schedule A and Schedule B land, and he removed the jhadi, and with the knowledge of everyone, he acquired everything, and he has been making a house and living over there. It was
Schedule C property.
yes, along with A and B. The whole 16 decimal he has acquired. Some land is vacant. In that my house is built. I have been staying there for a really long time. The witnesses have also come and deposed the same relationship. It was only in 1998, when I was carrying on some repair work, that the respondent representatives they came and stopped me, and thereafter I filed the title suit. I was in continuous peaceful possession for a long time.
But you have not claimed adverse possession.
Your Lordship, in the written statement, they have replied to my statement number 9
That is
that
not
I made
sufficient.
statement
Adverse
said-
possession requires certain basic pleadings.
It
Without
doesn't.
that, it
I
cannot happen.
have. But there is presumption of possession in my favor.
How does that make a difference? You went for a declaration of title, you could not prove your title.
Your Lordship, there is one judgment that talks about presumption of possession. If I face it.
Presumption of possession.
If
You
there
are
is
not claiming adverse possession. Can't be.
But in nature for section for schedule B land, where I'm claiming that my title is 1954 se continuous, and that too they have not denied my registered sale deed. If I have a registered sale deed, ownership is being followed by possession, your ladyship. My title is there to that particular land. Only on the basis that there is no recital in the particular document, my whole title cannot be disregarded.
Boundary is also not there in your sense.
Yes, boundary was not there.
Then how do you define and identify your property?
In the leader commissioner's report, your Lordship, which they have completely disregarded, that was
Makes no
appointed by the
difference.
court.
Even boundary in the same deed is not provided.
Yes, boundary
You
is
have
not
to prove
provided.
your own case. Essay number 409 of 2019. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 29/6/2019 with the bracket decree signed on 9/7/2019 bracket close, passed by learned District Judge Roman 4 Dhanbad entitled appeal number 29 of 2013, whereby the appeal preferred by the plaintiff has been dismissed. The judgment of the trial court is dated 31/1/2013 with the bracket decree signed on 14/2/2013 bracket close, passed by learned Additional Civil Judge cum Subdivisional Judicial Magistrate Dhanbad entitled suit number 138 of 1998, whereby the suit was dismissed. Consequently, the plaintiff is the appellant before this court. The suit was filed seeking a declaration of right title, interest and confirmation of possession for Schedule B property in favor of the plaintiff and against the defendants. Railways,
Yes.
defendants Union of India / Eastern Railway. The plaintiff also sought for a decree of permanent injunction restraining the defendants from obstructing the peaceful enjoyment of Schedule D property by the plaintiff. The learned counsel for the appellant, while assailing the impugned judgments, has submitted that the plaintiff was claiming right title, interest and possession with respect to Schedule A and Schedule B property by virtue of two registered sale deeds, Exhibit 6 and 6 by A, and the defendants were claiming the right over the property, stating that the property was acquired for railways in land acquisition proceedings.
Number 4 and 4/1 of 50 to 50.
Number 4
And 4 by 1
and 4 by 1
of 50 to 53.
of 1952-53. She submits that the defendants did not produce any document in connection with acquisition of property, and the maps, two plans and one map which was produced by the defendants and marked exhibit A, B and C did not reflect that the same were in connection with plot number 50 and plot number 51. The learned counsel submits that in spite of the fact that the defendant failed to prove their right over the property, and in spite of the fact that the plaintiff was claiming Schedule A and Schedule B property by virtue of two registered sale deed, the learned courts have decided the case against the plaintiffs. She submits that even before the pleader commissioner, the defendants did not produce any document with regard to acquisition of land. She submits that a substantial question of law be framed and case be admitted for hearing. After hearing the learned counsel for the appellants, the learned counsel for the appellant has also submitted that Schedule A property was 2 katthas in plot number 51, khata number 11, and was purchased, and the plaintiff was claiming right by virtue of sale deed dated 19/12/1949 within bracket exhibit 6. And Schedule B property was 2 kattha in plot number 51, khata number 11, and plaintiff was claiming the property by virtue of registered sale deed dated 20/1/1954, exhibit 6 by A. Schedule C property was 9 decimal of land in plot number 50 and 51, khata number 11, and she submits that it stands admitted that the same was encroached property of the plaintiff. She has further submitted that the plaintiff was seeking permanent injunction against the defendants with respect to Schedule D property, which consisted of Schedule A plus Schedule B plus Schedule C, total 16 decimal. After hearing the learned counsel appearing on behalf of the appellants, this court finds that the learned trial court had framed the following issues for consideration. Paragraph 4. Both the parties led oral and documentary evidence. Exhibit 6 and 6 by A was produced by the appellant, by the plaintiff, which were sale deed dated 19/12/1949 and 20/1/1954. Apart from other documents, the defendants examined only. The defendants produced 2 plans and 1 map, which were marked exhibit A, B, and C. Oral evidence was also led by both the parties. While deciding issue number 5, the learned trial court was of the view that though the plaintiff was claiming title on the basis of purchase from another person, but the title of the person selling the land as vendor could not be proved. the property was, the vendor was Motiram Mehto and Chudiram Mehto, but there was no evidence that they had the title over the property. The plaintiff also failed to prove that the documents regarding mutation of land was done on the basis of their postage sale deeds. The court also recorded that there was no mention of specific boundary of the suit land in their postage sale deeds and also in the plaint. The learned court ultimately held that the plaintiff failed to prove title over Schedule A and Schedule B property, as there was no evidence regarding the fact that Said Motiram Mehto and Chudamani Mehto were recorded tenant of plot number 51, khata number 11, and in that capacity they transferred the land by virtue of their postage sale deeds. The learned court also discussed the report of the legal commissioner and considered all other oral and documentary evidences on record. And rejected the plea of adverse possession the court recorded that the evidence of PW 1, 2 and 5 along with municipal documents did not show the possession of the plaintiff over part of the plot number 51 does show the possession of the plaintiff over part of plot number 51, but there was no evidence as to where this possession, as to when this possession was hostile to the real owner. And in fact, nowhere mentioned by the plaintiff as to whose land was encroached by the ancestor of the plaintiff, namely Suklal Bhagat. The court recorded that in absence of fulfillment of all the essential claims of adverse possession, the possession of the plaintiff cannot be deemed to have been perfected in title. The court recorded that the plaintiff has failed to prove his title over Schedule D land either on the basis of purchase or by way of adverse possession, and decided issue number 5 against the plaintiff. While deciding issue number 6 and 7, the court also held that the defendants have also failed to prove the fact that plot number 50 and 51 of khata number 11 of Moza Barmasia have been acquired by railways. However, observe that the issue number 6 and 7 are of no help in deciding the title and possession of the plaintiff. by deciding issue number Roman 2, the learned court found that no definite boundary was given in connection with the suit property. The court recorded that even in the sale deed, that is Exhibit 6 and 6 by A, the boundary was not given. And it was also claimed by the plaintiff that Suklal Bhagat had encroached upon 9 decimal of vacant land of plot number 50 of khata number 11. But again, in connection with the said property, no boundary was given. And ultimately, issue number 2 was also decided against the plaintiff. The finding in connection with issue number 2 in paragraph 9 of the trial court's judgment is quoted as under. The learned first appellate court framed the sole point, framed the point for consideration in paragraph 10 of the appellate court's judgment as under: 1. Whether the appellant/plaintiff has a valid right, title and interest possession over the land. 2. Whether the plaintiff has perfected their title over the suit by way of adverse possession. The learned court by the learned court held that the plaintiff failed to prove their title over the property. The court observed that the plaintiff had not disclosed the name of the vendors of the two sale deeds, had valid title to sell the land or not. The plaintiff had not stated anywhere in the plaint regarding the title of Shuraman Mehto and Matiram Mehto over plot number 51, and there was no recital in the sale deed regarding the title of the vendors. The court also recorded that though PW5 had deposed that the suit land was mutated in the name of his father Suklal Bhagat and rent was being paid to the government, but the plaintiff did not prove any mutation order or rent receipt, which further created doubt about the genuineness of the claim of the plaintiff. The claim of adverse possession was also rejected by observing that the plaintiffs had not proved the requisite facts with respect to claim adverse possession. The court further recorded that the plaintiff had not stated the exact date anywhere in the plaint on which date they had amalgamated the land with the purchased land. The court further considered the oral evidences and also observed that the learned trial court had observed that even the exact boundary of the suit land has not been mentioned in the plaint or even in the report of the pleader commissioner. And from perusal of the records, it appeared that neither the pleader commissioner was examined nor his report was taken on record. And hence the report of the pleader commissioner could not be considered at the appellate stage. The court recorded that the exact boundary of Schedule D property has not been clearly mentioned in the plaint, and therefore the learned trial court had rightly refused to declare the title of the plaintiff over the said land. There was no material on record to show as to whose land was encroached by Suklal Bhagat and when the possession became hostile to the real owner. This court is of the considered view that the plaintiff has to prove his case on merits, and the finding of the learned court that no definite boundary with respect to the suit property was given, nor the sale deed. The learned court has recorded a clear finding that no proper boundary with respect to the suit land was given, and even the sale deed on the basis of which the plaintiff was claiming title with respect to Schedule A and Schedule B property, no specific boundary has been given in the sale deeds. In such circumstances, this court is of the view that the learned courts have rightly dismissed the suit. The appeal has also been rightly dismissed. There is no substantial question of law involved in this case. The appeal is accordingly dismissed.
Item 24, second April 20 of 2021.
Come. Yes.
It is a matter of reversal valuation.
You are the plaintiff or the defendant?
Minus originally defendant. Minus is plaintiff. They had sought declaration of title.
Suit was decreed?
No, minus suit was dismissed. Suit was rejected on the grounds that there was no identification of land or demarcation, and also it was also discussed that it is barred against limitation. It is time barred and all of that, my lord. But my lord, at the appellate stage,
First appeal was allowed?
yes, first appeal was allowed in favor of these
And the suit was decreed?
respondents. Yes. The appellate
So you are the defendant?
Yes, my lord. The plaintiffs, they state that they had sold 2.25 kathas to me, but in 1990, and they state that me, the defendant, I was in possession of 2.5, and then I later encroached upon the other lands also, and then now I am in possession of 8 kathas, and then in 2003, there were 3 owners, my lordship, who claimed to have sold the land to this defendant, 2.25 kathas in 1990, and they state that in 2003, there was a partition of the rest of the land, and they realized that I had been encroaching on the rest of the land also, and I was in possession of 8 kathas, although only 2.25 was sold to me, and on this ground,
How
they
much
have
was
filed.
sold to you?
My lordship, 2.25 was sold.
So you are entitled only to 2.25?
My lordship, but I have stated in my evidence that the consideration amount paid was for 4 kathas.
How does that make a difference?
Yes, my lordship. But I have been in possession of this land, of full 8 kathas of land my lordship, since before the sale only, my lordship.
So you claimed adverse possession also.
No, my lordship, but they've not even identified the land or anything. They just claim that they have, in their evidence, they have two sealed deeds, my
Did
lordship.
you claim adverse? What was your right? Your right was only with
It
respect to
was,
2.25 pattas.
And possession, long standing possession, and they have
Did you
not-
claim adverse possession?
Yes, my lordship, I've said that I've been in I have.
Mere possession is not enough. Did you claim adverse possession specifically? Unless you claim it, unless you give the foundational facts with regard to adverse possession cannot be granted merely because you are in possession.
My lordship, I have just stated that I have been in possession.
That is not sufficient.
Although I am not the owner, so that
That is
amounts
not
to adverse possession only, my lordship.
Your possession since?
Since 1975, my lordship, but this sale deed that these plaintiffs that they claim to have sold to me, that is of 1990. That is for 2.25 kathas of land, my lordship. These plaintiffs, they have not even stated when their cause of action has arisen, my lordship, because they have not stated from which date I have come in possession of their
What is the
other
basis on
lands.
which they are claiming possession? They are claiming title, plaintiff.
They have said that earlier they had one sale deed. They had bought it from one Lalthari. Exhibit 1 and 2, my lordship. Exhibit 1 is the sale deed by which they have transferred it to me 2.25 kathas, which is of 1990, and Exhibit 2 is of 1989. So but my lordship, if your ladyship just sees, they claim that this Exhibit 1, which is a sale deed dated 26/9/1990, by which these three persons, Madan Mehto, Mohan Mehto and Surendra Narayan Singh, they have sold 2.25 kathas under 48 khata number and khata number 91, plot number 48 and khata number 91 to this defendant. And they claim that before that they had bought it from one Lalthari Kumar, by sale deed number 5099 dated 26/4/1989. And here the description of the land given is plot number 49 and 50.
You admitted that you were in possession since 1975, and then you yourself had admitted that you had purchased only 2.25 kathas. So you had no title with respect to rest of the land.
Yes, my lordship, but I was in possession.
Maybe, but you have not
Possession.
claimed adverse possession.
Yes, my lordship, but I have stated that although it was not sold to me, I have been in possession. And they have also not said anywhere when they have lost possession, my lordship. They have just said that in 1990 it was sold, 2.25 kathas was sold to me, and then suddenly in 2004 this has been filed, my lordship. So they have not described anywhere when their cause of action has arisen. And this partition that they say of these three owners, that has also not been exhibited, my lordship.
You see, Surendra Narayan Singh, Madan Mehto and Mohan Mehto,
Yes,
they purchased 68 kathas.
0.68 acres.
Yes, 68 kathas,
Yes,
right? From Lalthari Kumhar by a registered sale deed,
Yes.
26/4/1989. And they sold you only 2.25 kathas.
Yes, my lordship.
So-
In 1990.
That's right, in 1990.
Yes, my lordship.
Yes.
Until 2004, they have not taken any steps to remove me from possession or anything, my lordship. I have been in peaceful possession, I run my daily business there, and I have built a house and
Daily
there's
business?
a road, yes, Malaysia, a small daily business, and there is a road built on that land also, Malaysia. They have not even denied that. And suddenly in 2004, on the basis of these two sale deeds, they claim that they have not even identified what portion of land I have been encroaching and since when. They have exhibited one document which is a title suit number 90 of 2005, where I was the plaintiff and I have lost that, but that is against some other defendants. And that doesn't have any concern with this suit land also.
Essay number 20 of 2021. Heard the learned counsel appearing on behalf of the appellant. This appeal has been filed against the judgment dated 4/7/2020, within bracket decree signed on 16/7/2020, bracket close, passed by learned District Judge 1 Dhanbad in civil appeal number 21 of 2016, whereby the first appellate court has been pleased to allow the appeal preferred by the plaintiff and set aside the judgment dated 1/2/2016, within bracket decree signed on 6/2/2016, bracket close, passed by learned civil judge within bracket junior division, bracket close, -1 Dhanbad in title suit number 39 of 2004. The trial court had dismissed the suit. The first appellate court allowed the appeal, and consequently the defendant is the appellant before this court. The learned counsel for the appellant has submitted that the defendant was admittedly in possession since 1975 with respect to 8 kathas of land. And consequently, the defendant had perfected the title by adverse possession. Though the defendant purchased 2.25 kathas from the plaintiff by virtue of registered sale deed dated 26/4/1989. The learned counsel has submitted that the 2.25 kathas was purchased by, although the plaintiff was in possession since 1975. He submits that the courts have not properly considered the plea of adverse possession. The fact that the defendant was in possession of the suit property since 1975. The first appellate court. Both the courts have not considered this fact. Both the courts have not considered this fact that the plaintiff was in possession of the suit property since 1975. after hearing the learned counsel for the appellant and having gone through the impugned judgments, this court finds that the suit was filed seeking a declaration that the plaintiff was the rightful owner of 4 kathas of land under plot number 48, 49 and 50 under khata number 91 of village Dhansar, district Dhanbad, and also a degree for confirmation of his possession over the suit property, and if found dispossessed from the suit property, the possession be restored to the plaintiff. The case of the plaintiff was that 4 kathas of land, the 4 dismal. Is it 4 dismal or 4 kathas?
4 kathas, ma'am. They are
They claimed only 4 kathas.
Yes, ma'am. They have described it in Schedule B.
Okay. The case of the plaintiff was that four acres of land under plot number 50 0.16 acres under plot number 49 and it was the case of the plaintiff that in Mauza number 47, PS Dhansar, in Khata number 91, plot number 48, area 1.15 acre, and plot number 49, area 16 decimal, and plot number 50, area 4 decimal. The property to the extent of 4 kathas was recorded in the name of Bhadru Mehto, son of Gajadhar Mehto, which was in plot number 48, 49 and 50. Which was the land was acquired by Akli Kumharin through title suit number 373 of 1961, and she remained in possession of the same and left behind her only son, namely Lalhari Kumar. Lalhari Kumar came in possession, and after taking due permission from the Deputy Commissioner, executed sale deed in connection with plot number 48, 49, 50 by registered sale deed number 5099 dated 26/4/1989, area 68 decimal, with boundaries mentioned therein, to Madan Mehto, Suren Narayan Singh and Mohan Mehto, who jointly sold 2.25 kathas to the defendant in plot number 48, and with respect to the remaining, they divided amongst themselves and remained in possession. It was the further case that Madan Mehto and Mohan Mehto left their claim in favor of Suren Narayan Mehto. The case of the plaintiff was that the defendant slowly encroached upon 4 kathas of land and constructed a PCC road and in spite of objection on 28/4/2004, the defendant refused to vacate the suit property. Consequently, the plaintiff filed a suit for declaration of right title and interest in connection with Schedule B property. The defendant filed a written statement stating that the suit was barred by limitation, and also stated that the plaintiff Suren Narayan Singh, Madan Mehto and Mohan Mehto had sold the property in 1989 in plot number 48, 49 and 50, and then they sold 2.25 kathas to the defendant. She asserted that she was in possession of the property since 1975 and was in possession to the extent of 8 kathas, and has been utilizing the land for the purposes of keeping cattle, cows and buffaloes, and was engaged in business of selling milk. The learned court framed the following issues for consideration. Appellate court के जजमेंट में पैरा 4 में मिलेगा, कोई ट्रायल कोर्ट का जजमेंट हिंदी में है. Both the parties led oral and documentary evidences The learned trial court was of the view that the plaintiff was not able to prove that the property of that Surendra Narayan Singh got the property of Mohan Mehto and Madan Mehto also. The court observed that the suit was filed through power of attorney and Surendra Mehto was not examined. And that other co-owners of the property, namely Mohan Mehto and Madan Mehto, were not made party in the proceedings. The trial court ultimately dismissed the suit. And observed that the plaintiff has not been able to prove right title and interest and possession with respect to Schedule B property. And even the boundaries were not properly mentioned. So far as the learned first appellate court is concerned, the court framed the point for determination as under inverted comma. Is the plaintiff entitled for a decree declaring his right title interest over the suit property, and is he entitled for restoration of possession of the suit property? The learned first appellate court also considered the oral and documentary evidences on record and ultimately held that it was an admitted case of both the parties that Surendra Narayan Singh, Madan Mehto and Mohan Mehto had purchased 0.68 acres of land under Khata number 91, plot number 15 from Laldhari Kumhar through registered sale deed dated 26/4/1989, and they had sold only 2.25 kathas to the defendant by registered sale deed, which was dated 26/9/1990. Exhibit 1. Under Khata number 9, under plot number 48, Khata number 91. 0.68 is in connection with plot number 48 and 50 both.
Yes, yes.
48 and 50
Notification once, and
Yes,
one
please.
place it is written 49 and 50.
Whatever it is, but it is an admitted case that you purchase only 2.25 acres.
And these two.
Please hold on, just please hold on. The court also recorded that the defendant never claimed that she was the purchaser the defendant never objected that she was not the purchaser of the property. While Sailed never objected with respect to the purchaser of the property by Sailed number 50, Sailed dated 26/4/1989. The court held that Laldhari Kumar had sold 0.68 acres of land under plot number 49 and 50, new plot number 2, 3 and 4 under khata number 91 on consideration amount of rupees 8,500 to Madan Mehto, Surendra Narayan Singh and Mohan Mehto. The court also recorded that Parvati Devi had also filed a title suit number 90 of 2005 this is not required. The court also recorded that so far as the power of attorney is concerned, Sunil Narayan Singh had executed power of attorney in favor of Yamuna Prasad Singh to be present in the court. And also to negotiate in connection with and to execute sale deed for the land under 17 sale deeds, including sale deed number 5099 dated 26/4/1989. In view of the admitted position that the defendant had purchased only 2.25 kathas of land, that the defendant had purchased only 2.25 kathas of land from the plaintiff, from Surendra Narayan Singh, Madan Mohan and Mohan Mehto out of 0.68 acres of land. The learned first appellate court ultimately declared that the plaintiff was the rightful owner of the land mentioned in the Schedule B property. The defendant had no title in connection with property more than 2.25 kathas. The right title interest of the defendant with respect to 2.25 kathas has not been disturbed. The case of the defendant was, the defendant in her deposition had stated that consideration amount of 4 kathas was taken, but there was a sale of only 2.25 kathas. It is not in dispute that the registered sale deed in favor of the defendant was only for 2.25 kathas and not for 4 kathas. Merely because the defendant stated that she was in possession since 1975, the same by itself will not entitle the dependent for a degree of adverse possession. This court finds that no plea of adverse possession as such was taken by the defendant, and no issue with regard to adverse possession was also framed by the learned trial court or by the or any such point of determination was framed by the learned first appellate court. Considering the totality of facts and circumstances of this case, this court finds no substantial question of law involved in this case, which is accordingly dismissed.
Apart from this respondents, two other parties were also violated. So he has not even stated how they have relinquished, and there is no deed or anything.
He was the co-owner of the property, that is sufficient.
Item 25, second April 31 of 2021.
Is appealed by the plaintiff, respondent and appellant against judgment of reversal in a proceeding under section 87 of the Jharkhand Tenancy Act. Similarly, as a matter of fact, not the second appeal is provided under section 87 of the Jharkhand Tenancy Act, not where
It was against dead person.
it was not against the dead party, प्रतिवादी उनके legal heirs के against में भी हुआ है notice.
लीगल हेयर्स के सब्स्टिट्यूशन होकर
लीगल heirs का substitution
नहीं सब्स्टिट्यूशन नहीं हुआ सर। पैरा नंबर 10 देखिए।
उनका पैरा 10 में सबमिशन
नहीं पैरा 10 of the
after going through the evidence on record appellate court.
yes appellate court.
I find that the case number was filed by the respondent against two dead persons, namely such and such, both wives of Ramchandra Mato. The notices were issued against the dead person, but even after receiving the service report, the revenue officer ordered to publish substituted notice. The notice was published in a newspaper called such and such, which is not a widely circulated newspaper.
सर रिमाइंड किया है इसको प्रोसीडिंग तो कंप्लीट करेंगे ना Then service of notice, everything, what it published in a paper which does not have a circulation in the locality.
इस बात का जो लिखा है, why I am saying wrong, page 21, अगर देखेंगे the running page 21 of the original record, 21.
Yes.
सुनवाई हेतु प्लॉट नंबर के बाद सुनवाई हेतु बाद प्राप्ति के पश्चात वादीगण को सूचना निर्गत किया गया। सूचना प्राप्ति के पश्चात वादी न्यायालय में उपस्थित हुए बात के सभी त्रुटियों को सम्मन तामीला प्रतिवेदन से स्पष्ट होता है कि प्रतिवादी की मृत्यु हो चुकी है, जिसके वैध उत्तराधिकारी को सूचना प्रकाशित करने हेतु वादी द्वारा आग्रह किया गया। So petition was filed.
सूचना ऐसे नहीं
तो लिखने किया है। एक्चुअली सब्स्टिट्यूशन होने के बाद वादी के सब्स्टिट्यूटेड लीगल हेयर पर सूचना देने के लिए कहा गया। देन प्रसंगत स्थानीय अखबार के माध्यम से सूचना प्रकाशित किया गया। प्रकाशित अखबार के प्रति बात पत्र में संलग्न है। सूचना प्रकाशित होने के पश्चात भी प्रतिवादी पक्ष की ओर से किसी भी व्यक्ति द्वारा कोई आपत्ति नहीं की। इस कारण कार्रवाई एक पक्षीय प्रारंभ। So the notices were issued.
You see the
to the dead
notices,
person.
even if we say that the notice was issued through the substituted service or whatever, through newspaper it was published. They say that they did not have the circulation in the locality.
That is
Nothing, sir, nothing is
the widely published newspaper in the local area that has come on submission. That is their submission which have been recorded in the finding. And your Lordship will kindly see for a moment. The learned appellate court did not take into consideration nor reverse the finding. Only paragraph 10 he says that it was not, hence the present appearance of the
Bihar Observer कहाँ का प्रॉपर्टी है जो बिहार ऑब्जर्वर?
धनबाद का है, धनबाद से कॉपी
धनबाद में बिहार ऑब्जर्वर,
वही धनबाद से कॉपी होता है।
which is not widely circulated in the district of Dhanbad.
वो तो कह दिए, कोई एविडेंस नहीं है उसका,
इसका कोई मतलब
there is no evidence।
सर आपका रिमांड हुआ, आप आराम से सुनवाई करके ऑर्डर करवाइए। आपका कुछ खराब एडवर्स तो कुछ किया नहीं है।
पैरा 11 में कह दिए एडवांस हुई है। पैरा 11 में विदाउट एग्जामिनिंग ये टाइटल सूट पहले हुआ था पार्ट ऑफ द प्रॉपर्टी, और उस पर कह रहे हैं कि ये लोग हार चुके हैं इसलिए हम पैरा 11 दैट इज affecting my
नहीं, आपका रिमांड कर दिया है सुनने के
therefore
ऑर्डर।
that observation
नथिंग
shall not
नहीं, उससे कुछ फर्क
Prejudice
नहीं
the-
रिमांडेड फॉर
the-
फाइल फ्रेश ऑर्डर आफ्टर हियरिंग द अपीलेंट्स।
डिमांड होता सिंपलिसिटी का तो ठीक है, वो ऑब्जर्वेशन जो देती है फाइंडिंग
कोई observation
पैरा 11 in which the claim of the ownership and possession of the suit land by these respondents was rejected. It is obvious the respondents had suppressed the fact before the revenue office. But this is not the case. That judgment relates to a different property.
Yeah, all the contentions will be kept open. Certainly, उसको सुन के ऑर्डर करेंगे ना।
लिखे नहीं ना, अब वो एक्सेप्ट करेगा पैरा 11
कुछ नहीं
उस
affect करेगा।
सब प्रिजुडिस होंगे ना टाइप
नहीं होंगे prejudice। रिमांड किया है तो सारा ही कुछ सुनेंगे।
तो हुजूर का आइडिया है, लेकिन वहाँ का वो तो कवर्ड बाय द गाइडेड बाय द अपीलेट ऑर्डर। अपीलेट ऑर्डर इज द guiding factor. It should be decided. I don't have any objection. It should be decided openly, and everything should be considered and within a
Everything will be
specified period.
considered. ये तो second appeal substantial question of law।
But in that substantial question of law का जरूरत नहीं है, 87 है। तो ऐसे भी in routine course में not should be admitted.
No, सब routine course में it's not your।
CNP Act का 87 का ही proceeding है, सिविल सूट से नहीं है, इसलिए 100 सेक्शन 100 का जो मैंडेट है that is not applicable.
Second appeal number 31 of 2021। और
उसको जो एक ही चीज कर दिया जाए, that means everything should be considered without being prejudiced by this.
Or the learned counsel for the appellant. This appeal has been filed under section 87। आप 100 में फाइल कर दिए हैं।
हाँ, कर दें गलती से, फिर एक्चुअली 87 में होगा।
This appeal has been filed under the provisions of, this appeal has been filed against the judgment passed by learned District Judge Roman 4, cum MST Dhanbad, dated 31 January 2020, passed under section 87 of the Chotanagpur Tenancy Act in miscellaneous appeal number 205 of 2010. The learned counsel for the appellant has submitted that a second appeal is maintainable under the provision of section 87 of the Chotanagpur Tenancy Act itself before this court. And the provision of law has been wrongly mentioned as section 100 of the CPC. The learned counsel submits that it is a statutory appeal under the provisions of Chotanagpur Tenancy Act. He submits that the appellant before this court was the applicant before the learned revenue officer seeking rectification of the record of rights. Which was recorded in the name of the, yes, which was recorded in the name of the respondents. The learned counsel has submitted that notice was published Though the case was filed against dead persons, namely Fulmani Matain and Gauri Matain, both wives of Ramchandar Mehto, and the notices were issued against dead person, but after service report, the revenue officer had passed an order to publish substituted notice in the newspaper called Bihar Observer. He submits that the same newspaper has wide circulation in the locality, but it has been wrongly observed that it had no circulation. It was not widely circulated in the district of Dhanbad. Admittedly, the proceeding before the revenue officer was ex parte, and the defendants were the appellant before the learned district judge in miscellaneous appeal number 205 of 2010. After hearing the learned counsel for the appellant, this court finds that a proceeding under section 83, a proceeding under section 87 was, a suit under section 87 was under section 87 of Tobacco Tenancy Act was filed against dead persons, and when notice was issued, it returned unserved. And thereafter the revenue officer ordered to publish a substituted notice through newspaper, correct? But no individual notices were issued to the legal heirs and successors, and the notice was published in the newspaper Bihar Observer, and ultimately it resulted in ex parte judgment against the defendants. The defendants filed appeal, which was numbered as miscellaneous appeal number 205 of 2010. And contended that the revenue officer had committed serious error and had passed the order impugned in haste. It was also asserted that the plaintiffs were not the legal heirs of the recorded Rayat, and they were not connected in any way with Fulmati Matain and Gauri Matain. and many contested issues were raised before the learned first appellate court, as mentioned in paragraph 6 of the appellate court's judgment. It was also argued that the newspaper Bihar Observer is not widely circulated paper in the district of Dhanbad, and the appellants and the defendants did not get any information regarding the pendency of the case before the revenue officer, and they could not mark any objection. The plaintiffs, who were the respondents before the appellate court, objected and stated that the revenue officer found the plaintiffs in possession of the property, and after inquiry the order was passed. The learned first appellate court held that the newspaper Bihar Observer was not widely circulated newspaper in the district of Dhanbad, and also observed that, and on the basis of certain documents filed by the defendants before the appellate court, the court observed that the plaintiffs had suppressed certain facts before the revenue officer. The order of the revenue officer was passed ex parte, and the affected parties were not heard. And the matter has been remanded, and the order of the revenue officer was set aside. The matter was remanded to the revenue officer for passing fresh order after hearing the parties, and the parties were directed to appear before the revenue officer within a period of 2 months. The appellate court's order was passed on 31/1/20. This court finds that the learned first appellate court has primarily considered the fact that the notice was not duly served upon the defendants, and which led to passing of ex parte judgment by the revenue officer. This court, and consequently the appellate court, has simply remanded the matter for fresh consideration by the revenue officer. There can be no doubt that the revenue officer is bound to hear the matter afresh and has to pass the fresh judgment after considering the case of the respective parties, and without being prejudiced by the order of remand passed in miscellaneous appeal number 205 of 2010. This court finds no reason to interfere with the ensuing judgment, and accordingly the appeal is hereby dismissed.
It can be decided on its own then. Yes.
It is made clear that the revenue officer shall decide the case on its own merit. If not already decided, हो ही गया होगा तो क्या ही?
नहीं
नहीं. if not already decided. Dismissed.
Alright.
From supplementary list order Saturn 1 first appeal 180 of 2018. No, this is required. Appeal 176 of 18.
हाँ, कहाँ है appellant? Where is the appellant?
Orders limitation.
Limitation कितना दिन का?
Lordship, Mr. Pallav has just assumed the office we are in the process of getting the files, Your Lordship.
So
So we do not have.
this is 29 days delay. So in first appeal 29 days delay, what's the big deal about
Your
it?
Lordship, we do not.
It was filed in 2021.
Yes,
You have not even responded to it.
yes, Your Lordship. I was only.
We'll condone the delay. The case is fully covered. Numerous cases have been decided. There is no scope of taking a different thing.
Yes, Your Lordship.
So for this, you don't need to. I'll condone the delay. He can come tomorrow if he wants to. Right? Nobody appears on behalf of the appellant. Counsel for the respondents is present. IA number 2465 of 22 has been filed seeking condonation of delay of only 29 days in filing this appeal. One 147 days. Delay of 29 days कैसे? One इसके साथ supplementary affidavit लगाना है. ऑफिस नोट पे कितना डिले है?
इसमें 147.
कहाँ से देखें? कैलकुलेशन होगा ना इसका? देखिए जरा इसका कैलकुलेशन कहाँ से है? 29 days का ही डिले है as per office. Delay is only 29 days. Office नोट 29 days.
ऑफिस को तो वो क्या नहीं है.
वो पहले उन्होंने 147 डेज का फाइल किया था, लेकिन उसके बाद तो 29 डेज ये
यस.
है ना. The petition for condonation of delay was filed way back on 26/3/22. No counter affidavit as such has been filed. However, the learned counsel for the respondents has opposed the prayer for condonation of delay. Peruse the interlocutory application seeking condonation of delay. And being satisfied with the cause shown, the delay in filing the appeal is now condoned. Post tomorrow. This is covered by Judgment passed in
April 76 of 2018.
this case appears to be covered by the judgment passed by this court in first appeal numbers 176 of 2018 and other analogous cases. Which was being analogously heard. Yeah, that should be sufficient. Post tomorrow, first case, final disposal.
Your Lordship, if it may come on Friday, Your Lordship.
Friday. Friday as first case, 10:30. 176 का रिकॉर्ड है हम लोग के पास. You can have a look if you want to. कुछ टाइम मत मांगिएगा कि आप सोचना. There are numerous cases, numerous orders which have been passed following 176, arising out of the same acquisition proceeding. Only the rate of compensation with respect to the land has been enhanced to some extent.
I'll go through.
From date is order settlement second appeal 39 of 2005.
In batch of cases, I hope you are not seeking time. You have filed your written submissions. In that big batch, 600 cases.
Your Lordship will inquire from the central government councils who will appear.
You, for filing a written submission, you don't need. No, your ASDI was present on the last date. He is aware what is there. I told him that I will not grant you
Your
time.
Lordship, Mr. Pallav is in cognitive.
Because anybody may die any day.
Yes.
And then the case will be adjourned for another 1 year.
Your Lordship.
And in the meantime, more people will die.
He has taken note of that matter.
Yes. Yes.
In this report notices, we can see office notes also. The respondent number 7B, 7E and 7F refused to receive the notice.
What else do you want to say?
Respondent number 7B, 7E and 7F.
Essay number 39 of 2005. As per the office note, respondent number 7B, 7E and 7F refused to take notice. Accordingly, the notice upon respondent number, aforesaid respondents is accepted as valid. और बताइए.
The respondent number 4A and 4B received by sale.
The notice has been duly served upon respondent number 4A and 4B. Then
There are also notice of respondent number 4C to 4F, 6A, 7C, 10C to 10F not found lost. I may be permitted to take fresh state lot in the
notice upon respondent number 4C to 4F, 6A, 7C, 10A to 10F, and respondent number 6B to 6D, 7A and 7D could not be served as they were not found at the given address. Learned counsel for the appellant prays for and is granted 1 week time.
No, 3 weeks lost. Address पता करना lots of address
3 weeks
पता
time
नहीं
to take fresh steps upon the for service of notice upon the aforesaid respondents at their present and correct address.
One more clear loss.
One.
Mechanism office note respondent
एक
number
second, just a moment.
एक का आंसर 2 का आंसर बताया 6E and 6F.
आंसर आप क्यों लौटा है?
उनका रीजन नहीं दिया हुआ है।
Incomplete address.
अब इसमें फ्रेश कर
इसमें भी कर दीजिए.
जी
6A to 6D भी इसमें डाल देंगे. ठीक है? At their present and correct address. Through speed post.
3 yes
Through speed post. है ना, सबका through speed post. और बताइए
प्लस
ये 4C का name and father's name does not tally.
इसका ही फ्रेश नोटिस कर
ये notice क्या name and father's name does not tally. इसका क्या मतलब? 4C.
4C
Postal PN दिया है, name and father's name does not tally.
4C अरुण साहब
Name and father's name does not tally. इसका क्या मतलब है?
तो जो बताया गया रिस्पोंडेंट वर्सेस के लीगल ईयर्स है मीना देवी, अनिल साहू एंड अरुण साहू। ये बताएंगे कि हु इज द रियल।
आप ही बताए थे इनको,
नहीं बताए थे, वो हमारे
तो आप ही
क्लाइंट
बताइए क्या एरर है।
हम इसमें वेरीफाई कर लेंगे।
Whom are you representing?
I am representing the original landlord. How they are concerned, I just fail to appreciate them.
रिस्पोंडेंट नंबर 6 राम इकबाल साहब।
इसको किसको?
डिग्री जो रिस्पोंडेंट है उसी के साथ
कहाँ के हैं लोग?
हैं सिमडेगा के लोग।
Present in correct address to the concerned police station करिएगा, स्पीड पोस्ट मत करिए, वही बताएगा क्या काम है।
ठीक सभी का
सभी का प्रेजेंट एंड करेक्ट एड्रेस पर जो भी रेस्पोंडेंट्स है 4C भी उसमें इंक्लूड कर
फोर
दें,
सी
भी।
फोर सी
ठीक है।
सबसे अच्छा
हाँ।
वो खोज लेगा।
वो खोज लेगा।
हुजूर का ऑर्डर रहेगा तो एकदम करा के खोज
सर्विस हो क्या आ जाता है।
तुरंत
सर्विस हो जाता है।
पोज दिस केस ऑन 3 वीक्स का आपको टाइम चाहिए, जनवरी में डालिए, 5 जनवरी
ओके
अवेटिंग सर्विस।
Item 9, second April 74 of 2017.
The last order 11/6/2025, this appeal was admitted. The report was called for and thereafter the state respondent number 3 has been directed, 1 and 3 has been, the state has been directed to serve the notice upon respondent number 2.
The jointer has been filed on behalf of respondent number 3. तो
1 and
respondent
3 are 1 and 3 represent.
नहीं आपको समझ नहीं आ रहा क्या प्रॉब्लम क्या है।
इसमें respondent number 2 को notice हुआ,
could not be traced out.
could not be traced out. Thereafter, the initially, the paper publication was also done. And that to that effect, the affidavit has been filed.
After paper publication.
Yes. Thereafter, this matter was heard and admitted and
Fresh notice was issued.
fresh notice.
आपको fresh paper publication करना पड़ेगा।
वो स्टेट के थ्रू बात है, एक बार ऑर्डर देख लीजिए 11/6/2025 पैराग्राफ 6 ऑफ दैट।
ये तो सर्विस ऑफ नोटिस का ना, तो फाइल किया है स्टेट ने सर्विस ऑफ
हाँ
नोटिस।
फाइल
तो क्या हुआ, ट्रेसलेस है क्या है?
ट्रेसलेस ही है डॉक्टर।
ट्रेसलेस है।
एफिडेविट दिया था कि वी ट्राई टू लोकेट बट इट इज नॉट ट्रेसेबल।
शुरू से ही है, हम लोग कितना बार नोटिस हुआ
नहीं आपको इसको पेपर पब्लिकेशन लेना पड़ेगा ना, फिर से पेपर पब्लिकेशन लेना पड़ेगा। वी कांट हेल्प इट।
क्योंकि उस समय किए थे तो दैट में भी टेकन
इट कांट ना, उस समय तो डिले पर होगा। यही प्रॉब्लम है, डिले पर अगर एक बार नोटिस होता है तो मेरिट पे फिर नोटिस होने से तो फिर से नोटिस करना पड़ेगा। ऐसे नंबर 74 of 2017 the notice upon respondent number 2 through the concerned police station could not be served as the respondent number 2 is stressless. Counsel for the appellant please for कितना टाइम में सब्स्टिट्यूट सर्विस तो फाइल करना पड़ेगा ना, 3 हफ्ता लगाइएगा। 2017 का अपील करना नहीं लगता।
नहीं 2 वीक
Praise for 2 weeks time to take appropriate steps for substituted service of notice. Post on 26 November. Supplementary contest. उस दिन फाइल कर दीजिए तो ऑर्डर कर देंगे। सोच के रखिएगा कौन से न्यूज़पेपर में करना है।
वो जो पहले में जो किए थे
हाँ उसी में
Attend case second appeal 216/2018.
In this case not by order dated 11/9/2025, the notices were directed to be issued against the proposed big areas of respondent number 3, 4 and 5. The office note shows me not through speed post. The track according to track report, the notices upon respondent number 3, Roman 1 to 3, Roman 4, 5, Roman 1 to 5, Roman 2, and 6, Roman 1 to 6, Roman 3
Has been delivered.
have been delivered on 3rd October 2025. Nobody has appeared. And the interim order was not till date. By order dated 21/11/2025. I do not find any appearance either in the list or.
Essay number 216 of 2018. Section 5 में भी notice हुआ था
जी उसी में नोटिस
और substitution में भी notice.
जी.
The learned counsel for the delay कितना है 117 days.
117.
The learned counsel for the appellant has submitted that notice was issued to the proposed legal heirs and successors of respondent number 3, 5 and 6.
And the contesting respondent 1 and 2 they have already been served and it has been varied.
In IA number 7014 of 2025, he submits that as per the office report, the notice through speed post has been delivered. The learned counsel submits that the petition for substitution be allowed.
Respondent 1, 2 and 4 they have already received. It has been
The learned counsel submits that the contesting respondents are respondent number
1, 3, 1, 2, 3, 4.
1 to 4
1, 2, 4.
have already appeared.
1, 2 and 4 appear.
1, 2 and 4 have already appeared.
Yes, 3 का bigger areas को notice हुआ.
Okay. In spite of service of notice.
Appeared, they didn't appear in.
Yes.
In spite of service of notice. 1, 2 and 4.
And the learned counsel submits that the respondent number 1, 2 and 4 who are the contesting respondents in this case have not appeared in spite of service of notice. कितना डिले है सर?
101. And 17 Karawan. The judgment was passed
6205 days है आपका substitution में delay.
substitution because they were the apparent they did not take any step. It was brought to the notice of this honorable court also. Brought to me after service of notice when we found that they have died. We were the respondent in the court of appeal. Defendant.
When did they expire? Oh, they died during the pendency of title
Pendency
appeal.
of the title suit.
Title suit or title appeal?
Title appeal. We were the defendants, then
No,
respondent.
somebody died in 2008.
8 no, the appeal was pending.
No, 2008. Okay.
Appeal filed on 1998. The appeal was filed on 27/8/1998. So during the pendency of the appeal they died. We were the respondents. They were the appellants.
Pose this case tomorrow for appropriate orders under the heading for orders. कल इस पर थोड़ा देख के ऑर्डर करेंगे बहुत ज़्यादा डिले है.
The day after tomorrow.
Day
After shooting.
Yeah. बहुत ज्यादा डिले है।
हाँ, ये तो that is the fault on the part of the appellants.
तो
Appellants in the landed court, they didn't take any step. They were the former respondent in the appeal. Three parts.
अब फर्स्ट अपील कौन फाइल करेगा?
First appeal, agent respondent 1, 2 and 4.
They did not take any
They did not
steps.
take a step in the appeal. Now in second appeal, they were their names appearing in the decree.
That's
Therefore, I included them as a party
That's
respondent here.
We'll pass an order.
All right.